The Punjab and Haryana Court held that communication as outlined in Rule 127 of the Income Tax Rules 1962 cannot be presumed simply by placing a notice on the e-portal. The court pointed out that an individual or a company cannot be expected to keep the e-portal of the Income Tax Department open all the time to know what the department is supposed to be doing regarding the submissions of forms, etc. The provisions do not need to mention as far as a mention of the communication to be presumed by placing that notice. A pragmatic view has to be adopted always in these circumstances, is what was said in court. We have my colleague Ghazali joining us to get us more on this. Ghazali, a huge, strong words being used as far as the court is concerned in order to pull up the income tax officials, saying that, they have to keep the communication line open. They need to, come out with more than just putting stuff out on that e-portal.
A very significant order, and the background of the case is such that this was a Ludhiana-based firm, which was issued notice by the Income Tax Department, but the notice was put up on the e-portal or the website of the Income Tax Department. And after the Ludhiana-based firm didn't react or respond or reply to that notice, the Income Tax Department put 2 reminders, and those 2 reminders were also uploaded on the website. And that is when, for the violation, the Income Tax Department pulled up the Ludhiana-based firm. The Ludhiana-based firm approached the High Court, and that is when the High Court gave this order that you have to look and take a very pragmatic approach, because not every individual or firm or an organization will keep checking the income tax website or the portal to see that what has been notified or communicated by the department. And earlier, the High Court also said that earlier the means of communication used to be that hard copy of the notice was to be delivered by post, then communication is started drifting towards email or electronic mail, and consumers or customers used to be notified by that. But in this particular case, no email was sent, and what the Income Tax Department said in the court was that since this firm had an online account, so we presume that perhaps they will also check the portal and will be receiving this notification. That is when the court said that you can't presume in these circumstances, rather you'll have to adopt a pragmatic approach and ensure that all these notices are personally served to them through other means as well.
Right. Thank you so much, Ghazali, for highlighting all that was said in court.